welcome, welcome, welcome to everyone. Thank you for joining us. I'm Mark Gilfix, and this is Michael Gilfix here with me. The topic of our talk today, what now? So 2022 estate planning updates. We're going to be going through a lot of really critical issues, and we're going to go through some tools that you can use for your family, for yourself to protect everything you worked for. And as we jump into this, and we thank you again for spending time with us here today, I want everyone to take just a moment to think about, why did you join us here today? Are you worried about your finances? Are you worried about your family's future? Are you worried about just general legal issues and financial issues and stuff you're not sure of? Do you just feel overwhelmed? I think we can all relate. The last couple of years have been madness in so many ways, unprecedented, so much swirling around, so much chaos, so much change. There's so much that we can't control, but there are a lot of issues that we can control. And that's what we want to talk to you about. We're here to help. We want to give you some specific action items to protect your family from the legal planning side of things. We can't help in every area of your life, but we can definitely help here. And we want to empower you with knowledge. We want to empower you with wisdom and impart to you what we've learned in the last, well, as our practice, nearly 40 years. Really, really important issues. And we think you're going to get a lot out of this.
And it could at a glance seem like kind of an overstatement to say that we can affect and really modify your family's future in positive ways. It's not an overstatement. As we go through some of these issues and talk about solutions, how to make sure that your family home is not lost. There's threats, there's tax threats to retaining ownership of your home and your family. I mean, it's amazing some of the challenges that are out there waiting for you. So much is possible to protect things for your family, your kids, the perfect grandkids. By the way, I should say, because of COVID, et cetera, I'm doing this webinar from home. I'm actually in my office, which is also known as the nursery for my grandkids. So that's his crib right behind me. It's kind of a nice prop as I think about it for doing this webinar. It's all about the family. It's about multi-generations and how do we make sure that things are protected.
Yeah, and it's amazing what we can achieve. And as we jump in, again, we're not going to be able to get to questions as we go. We have too much to get through, but please submit them via the Q&A function, and we'll get to as many as we can at the end. We did get one question about closed captioning. So for the live webinar, we can't do that. We do, if you're watching this as a recording, we hope to add that there, but unfortunately can't do it for live. We have some key issues we're going to go over here today. Creating a plan, why your living trust must be reviewed, and if you don't have a plan in place, why it's so critical to put one into place. The secret to protecting assets for future generations from divorce, from lawsuits, and from estate taxes. Amazingly powerful tools. Prop 19, something that anybody who owns real estate in California needs to understand, and how it could potentially devastate your family and what you can do to avoid that. The future of the death tax or the estate tax, what that means, what you need to know about it, what you can do about it. We're going to talk about special needs planning, what you need to do there. We're going to talk about Medi-Cal and long-term care planning. Lots to cover, but we're going to get you through this very efficiently. Just have to note, this is an educational webinar. This is not intended to provide you with specific legal advice. We're here to give you knowledge. To give you legal advice, we have to work with you formally and know your whole situation. But I think you're going to get a lot out of these next few minutes. And as we get started, I want to introduce my co-presenter here today, Michael Gilfix. I've known Michael for over 40 years because, as is probably pretty obvious, he's my dad. So from the day I was born, I have known him. And I think it's just critical to point out his background because it's pretty extraordinary. And he's kind of an American success story. He grew up in a little town in northern Michigan, came out to California, go to Stanford, graduated Stanford Law School in 1973, and immediately set out to change the legal world. He created America's first free legal aid program for the elderly, SALA, Senior Adults Legal Assistance, still exists to this day. And in doing that, helped to create the field of elder law. He trained hundreds of other attorneys around the country in this field. And he raised money, he testified in front of Congress, and really started a movement and started a whole new area of law, an area of law focused on the needs of older Americans. and really changed the game. After running nonprofit for 10 years, he went into private practice, Gilfix and Lippold Associates. He started with my mom, Myra Gerson Gilfix, and has remained a national leader. He writes a form book for other attorneys. He writes articles and books. He's in the media, the Wall Street Journal, USA Today, all over the place. And it's a privilege for me and the rest of our team to have him as a mentor and as a guide. And I think it's a wonderful thing for our community as well. So without further ado, I want to introduce Michael Gilfix.
Thank you, Mark. By coincidence, I've known Mark more than 40 years also. It's very, very mutual. So about Mark, just a few things. Mark also went to Stanford as an undergrad. He went to another law school where he graduated at the very top of his class. He was a class speaker. I mean, that's kind of an honor and an acknowledgement of leadership and excellence. When he graduated from undergrad, he actually began work in one of the top international consulting firms in the world. Tremendously successful there. So many other things I could mention, but I'll just mention that since he's joined us, Mark has received awards. As far as awards go, more than I have. Now that I think of it, darn it, more than I have for writing and speaking. And he too is speaking all over the country and doing a tremendous amount of writing and leadership. For example, there's a national magazine called Trust and Estates, a dry name, but in the field, it's sort of the dominant publication for attorneys, financial advisors, CPAs, et cetera, about how to do trust and estate planning. Mark has a long article that advises attorneys about how to advise their clients about cryptocurrencies and all of these new tools in the world of blockchain. Very much in demand. So a leader. And probably the most important thing that I think Mark brings to the field is the perspective of the next generation. Mine is the older generation. I do have a certain way of looking at things, and Mark's is different, and it adds layers of perspective as we do the work that we do for our clients. It really makes us more effective as we do our work day to day. So privileged to be working together.
Thank you. And just about our firm, for those of you who don't know us, I think the key thing I want to point out is just we've been in this community for just under 40 years. Work with thousands of families and neighbors and friends and people throughout the state of California. Really, we can help anybody in the state. And our goal is just to provide extraordinary return on investment and value. We want to address issues holistically and help your family.
And yes, that is Mark in his grandfather's arms in the picture, by the way.
There's a lot of me in this right now. I'm a little uncomfortable. We need less Mark in this beginning part of the webinar, maybe. So as we explore these issues, I want to jump in now to some mysteries and some stories. The tale of supercharging a plan. Larry and Wyatt. This is to illustrate the power of planning ahead. And now imagine Larry and Wyatt in basically identical situations. Each of them, $2 million is left for them by their fathers. Each of them endures a divorce and a lawsuit during their lives. Larry, when he passes away, all that $2 million is gone. It's vanished. It's out of his estate. Nothing for his kids, and of course, nothing for his grandkids. Wyatt, same life, same situation. But because of something his parents did differently, his children end up with $6 million from that, and his grandchildren end up with $18 million. 0 versus $18 million. What did Wyatt's family do differently?
Good question. This is another mystery, a tale of protecting assets. Here's two couples, Wanda and Dave, and Susan and Jim. Similar in the sense that they worked really hard, developed an estate, and they have a $20 million estate. I mean, that's substantial by any measure. When Wanda and Dave pass away in or shortly after 2026, over $5 million is lost in estate taxes, like a quarter of the estate. Staggering. Susan and Jim, same profile, but the radical difference, when they pass away roughly at the same time, no estate tax whatsoever, all the money stays in the family. So again, how do they do it? What's the mystery here?
And one more mystery. We're going to go through these as we go through our talk. Protecting the family home. Tom, Jill, and Amos. Imagine all three of them are in the same situation as we get started. Each of them owns a house in the Bay Area. It's worth $3 million because they bought it decades ago, and it's just gone up in value. It's not even a huge house in many parts of the Bay Area. The assessed value used for property taxes for each of them is low. It's only $300,000, but Prop 13 means that their assessed value stayed low while the market value went up. Each of them passes away in 2022. Tom, when he passed away, his daughter inherits the house. She decides to rent it out. Property taxes increase from $3,000 a year to over $30,000 per year. Jill, same situation. She passes away. Her daughter inherits it. Her daughter decides to live in the family house. In her case, though, property taxes still increase, not quite as much, but they still go up from $3,000 a year to over $20,000 a year. Amos, on the other hand, same situation. But when Amos passes away, his daughter takes ownership of the house and property taxes don't go up at all. They stay at $3,000 a year. What's the difference? What did Amos do differently from Tom and Jill? And what does that mean for you? We're going to uncover these mysteries as we go. Now, as we get started, just some 2022 tax updates. Our focus here is on gift and estate tax, not income tax. That's not our world. But from an estate tax standpoint, important to know the exemption, the amount that you can pass to your kids free of tax has actually gone up. It looked for a while like it was going to go down. The last minute, no change. It's now $12.06 million per person. It's a little higher than last year because it's adjusted with inflation. The annual gift exemption, the amount you can give to anybody without even reporting it to the IRS, that went up from $15,000 a year to $16,000 a year. However, as we're going to talk about, the current estate tax exemption is probably going to change in the near future, so we got to be ready for that. Prop 19 is a major issue. That's a new law that passed last year, and it is fully in effect now, and you need to understand that. So, setting the stage. As we get started with this section, we're going to talk about core basic estate planning documents that really everybody needs. And I think you need to ask yourself, do you have an estate plan? And even if you have one, has it been years since you created your plan? We're going to point out why it's so important to revisit it. And we can certainly help you with that. And what are the 4 documents?
Well, there's 4 fundamental documents that everybody should have in place, or at least 3 if you don't have kids. One is a revocable trust. I mean, it's the cornerstone. It's something everybody should have. The best known benefit, avoiding probate, but there's other benefits as well. Durable power of attorney for financial affairs, where you name someone who has authority to sign your name, act on your behalf if you become incapacitated. Kind of obvious that you should do that. The Advanced Healthcare Directive, where you give someone you trust the authority to make healthcare decisions for you if you can't, to be your healthcare advocate. So important that we nail these issues down so that the medical community and your family knows what you want if difficult circumstances ever come into being. The Family Protection Trust, which Mark is going to talk about in a few minutes, we view that as one of the 4 essential documents, and Mark will certainly explain why. It supercharges the plan, protects the family for generations. Fundamental documents for everybody. So let's look at the trust and talk about why it has to be reviewed. It's just so typical. I can't tell you how many times over the years I've heard somebody say, "Well, I have a trust. I'm done. I don't need to do any more planning. I'm fine." That's so artificial and just fails to understand what trusts are really all about. Circumstances in your family, the circumstances have changed. I mean, we all change, we evolve. There's developments one way or the other in the family, size of the estate, who knows what. Unique or special needs. What if it turns out that a child or a grandchild has special needs, which in this context means that they can't work, they can't make a living, that they're challenged in some way. You have to take that into account, and standard trust planning doesn't do that. You have to review the structure of your trust. Even if we did your trust years ago, more than 3 or 4 years ago, we would have done for you what is generically called an AB trust for a couple. It divides into 2 trusts after the first death. Pretty typical and standard to do it. There have been changes in the law so that might not be necessary anymore. You can still get the tax planning benefits, but it might benefit from actually simplifying your trust. It needs a review. Is it funded? In other words, are all of your non-retirement assets titled in the name of your trust? If not, it won't avoid probate, which is, again, one of the most fundamental benefits of having a revocable trust. And by the way, you could own real property in Michigan and Utah and Massachusetts, and those properties can be titled in your California trust, and it avoids probate. It brings all of them under the umbrella of your trust, but you have to title them that way, or there could be probate. The next one is just huge. The choice of your successor trustee. When you set up a trust, you are the trustee. If you become incapacitated, somebody else takes over. Years ago, you named somebody, maybe one of your kids, maybe somebody else. Well, are they still your choice? Are they still the most responsible person in your view? 30–40% of the time, over time, people change the name. They have a different person in mind. Again, circumstances evolve. Next, do they have a family protection, a dynasty trust in place for the kids and grandkids? If not, at least you need to seriously consider it. You probably had to do it. So bottom line is if your trust is, we would say actually 3 or 4, but certainly if it's 5 years old and you haven't reviewed it and gone through these and other issues, it's got to be reviewed. It's got to be up to date. Next point is that, again, as I said before, there's so many people who say, I've done a trust, I'm done. A revocable trust is not enough. It's only one element of a good plan. Even when you look at these the power of attorney and the advance directive, there's more issues there. If you have a revocable trust and your home and other property is in your trust, it doesn't address the Prop 19, the property tax problem that we'll be exploring a little bit later. It doesn't help a bit. It doesn't necessarily eliminate estate taxes. Again, having a trust is not tantamount, it's not the same as tackling trust exposure. Tax exposure. It may or may not. And it may or may not eliminate all capital gains tax. You always seek this thing called the stepped up basis. Will all assets get the stepped up basis? Maybe yes, maybe no. Critically, having assets and a living trust does not protect those assets from litigation. Kind of a myth about that. Again, heard it so many times. I'm safe. I let them sue me. My money's in my trust. Not so. Your money in your trust is exposed.
And so while a living trust, this is not to say you don't need one. You do. It's just that it's part of a plan. And if you don't, and you may be sitting at home being like, well, I don't have a living trust at all. What are you guys talking about? Talk to us. You need to get one in place. We'll get you in. We'll help you to set up a core living trust as part of your core estate plan. Critical to get that done right the first time, because if there are any weak links in your plan, those can be exposed and can cause all sorts of problems. So it's really worth getting it set up right the first time. And we can, of course, help you with that, as we've helped thousands of families to do that. And it's not just the living trust.
Yeah. So, we talked about the living trust and what you have to monitor, how to make sure that it operates properly, and is it up to date in all respects. And you might think that a power of attorney is a simple standard form. It is for many people, but that's not appropriate. Many individuals, many attorneys use what's called the statutory form. It's a 2-page form. You check some boxes and you're done. For most situations, that really is fine. But most of us are not vanilla. Most of us have issues that have to be addressed. Powers of attorney can be critical. Simple example, you're going to do some tax planning or set up a special needs trust for a kid, whatever, but you lose capacity, you become ill. Everybody knows what you wanted to do, but you can't sign these new documents anymore. If your power of attorney is going to authorize you to take those kinds of steps, the power of attorney has to have explicit language authorizing you to do so. Same about long-term care and asset protection planning. If steps are going to be taken to reorganize assets, you can't just do that with the simple basic power of attorney. It needs to have special authorizing language. It's a matter of just being up to date, understanding what the law requires and where some of the gaps are, just making sure that your assets aren't lost because of inadvertence when all the tools are available to you.
Now, let's shift gears. And I want to tell you about the secret way to protect assets for future generations. And honestly, this kind of is a secret. It's something that ultra high net worth families, billionaires and decamillionaires have been doing for a long time. But I want to let you in on this secret because you can do this too. There are extraordinary tools. Now, what is the way that you can protect assets for future generations? Simple. Don't leave anything to your children. Easy. So obviously that does protect assets, I guess, from your children's creditors because they have nothing to lose. But let's say you do want to leave assets to your kids. I still say don't leave them a penny. Instead, leave assets to family protection trust. So just to be clear, you'd have your living trust. And when you pass away, you'd leave assets not to your kids. So you have 2 kids. You would not leave it to your son and your daughter. You leave it to family protection trust for your son and family protection trust for your daughter. Why would you do this? Why does Bernie Sanders want to get rid of these? This is not a political statement. He's on record saying that he doesn't think these should be allowed, but they are. And that's why it's so important for you to be aware of these incredibly powerful tools. Why would you do this? Well, by leaving assets directly to family protection trust rather than to your child, as you'll see in the media, you can Google the term dynasty trust is the generic type of trust these are. Ours are family protection trust. That's our custom version of this. 3 benefits. 1, if you leave assets to your child and they get married and endure a divorce, if they commingle inherited assets that they get directly, those are lost to that douchey ex. If it's in a family protection trust, those assets are separate. They should not be subject to a divorce settlement. They should be protected. If your child's sued, if they're in a car accident or a bad business deal or something like that, assets they inherit directly, absolutely reachable by litigants. In a family protection trust, there's a high level of protection. There's a barrier protecting what you left for them. Third, this is hard to wrap your head around, but it's really important. Anything your child inherits directly, plus anything that they earn during their life and invest, that's all part of their taxable estate. So when they pass away, 30, 40, 50% of that could be lost in estate taxes, depending on whatever estate tax laws are in the future, 30, 40, 50 years from now. Assets left to a family protection trust, subject to some limits, are exempt. They should not be touched by estate taxes when your child passes away and when these pass for the benefit of your grandchildren. Even if you don't consider yourself high net worth, that's where when you look 1-2 generations in advance, ahead, it can be millions and millions of dollars in difference for what's there for your family. And you might think, okay, this is cool, but I don't want to tie my kids' hands. I don't want to have a bank as trustee or anything complicated. Well, if you allow it, your child can be his or her own trustee. They can be in charge of this trust for themselves. So in many ways, it's the best of both worlds. You're leaving assets there to support your child. They're in charge of it, but yet they get these incredible protections. And when you look across generations, it is extraordinary what we can achieve when we set these up right now and in the near future. And how long do these trusts last? Well, they last about 100 years under California law. It's kind of an oversimplification, but really you're protecting your kids and your grandkids from divorce, lawsuits, and estate taxes. It's kind of like doing a prenuptial agreement for your grandkids, which is kind of crazy to wrap your head around. And sometimes that's all that our clients need to hear, especially moms. I think they hear prenup for my kids and grand. Yes, we're in. And again, I like to make this point. It's not just for the ultra wealthy. You read stories about ultra high net worth people finding all these loopholes and ways to protect their assets that aren't available to the rest of us. This tool is available for the rest of us. You do not have to be ultra wealthy for this to make a lot of sense and to put this into place. Now, if you are high net worth, then it's even more valuable. And of course you should do this, but we recommend this for virtually every family that we work with. And the majority of them do create these trusts. So I want you to be aware of this tool, whether you decide to do it or not. I think every family should. This is an extraordinarily powerful tool. So something we want to point out now, circling back to the tale of supercharging a plan. Remember Larry and Wyatt, each of them inherits, or $2 million is left for their benefit. Larry ends up with nothing. His grandchildren end up with nothing. Wyatt and his kids end up with 6 million. His grandkids, 18 million. What's the difference? Well, Larry's father left him that $2 million directly. So when he was sued, when he was divorced, that money vanished. Wyatt, when he was sued and when he was divorced, there was this barrier protecting it. So that money stayed there for his family. The difference over multiple generations can be tens of millions of dollars, even if you're not starting out with much. If you just own a house in the Bay Area, that's probably enough to justify this and mean tens of millions of dollars could be at stake when we look to the future.
So the bottom line here is with that family protection trust, Larry loses and Wyatt wins.
That's right. That's right.
We
Let's
love
shift
alliteration.
Yeah.
Let's talk about disability and special needs for just a moment. Now, this is a topic that we could spend 1-2 hours talking about because there's so many problems that come up and so many opportunities. But just to get down to the basics, this is planning this is the exception to Mark's comment earlier about leaving assets in a family protection trust. If you have a child or perhaps a grandchild who has a disability, and in this context, disability means that he or she is not able to work and make a living. We usually think of autism where the incidence of autism is just growing dramatically. A lot of speculation about why that's the case, but it is the case. So many issues or problems can result in a person being disabled. It could be alcohol or drug abuse. So again, if a person is not able to work because of some physical or psychological problem of some sort, they're going to qualify for a number of government benefit programs. The programs provide income, healthcare through the Medi-Cal program, housing through Section 8 and other programs. All of them are needs-based programs. In other words, if you have too much money, you don't qualify. Currently, the limit is about $2,000. So what do you do for a child who has a need, but you want them to qualify for these government benefits to which they have a right? The answer, 98% of the time, is a special needs trust. So if you have two kids, one is disabled, one isn't, one gets that family protection trust, the other one gets the special needs trust. Any amount of money, any asset can be in a properly drafted special needs trust, and it will not interfere with eligibility for government benefits. So it's kind of the best of both worlds. Utilize the government benefits for which the individual qualifies and to which he or she has a right, but also has to have this lifelong safety net of money that needs to be there if they're going to have a quality life to pay for any items or any services that are needed and that aren't provided adequately by some of these government programs. It's like a lifelong safety net is the best way to think of these trusts. It is essential. It works. We have done hundreds and hundreds of these trusts, always with success. Obviously, this is an issue that is nearest and dearest to our hearts. And Mark serves on the board of directors of one of the autism organizations, the nonprofits here in the Bay Area. So we've been working on these issues literally for decades, and it's, as I said, probably the most important work that we do.
Yeah.
The ABLE Act. Oh yeah, sorry, Mark.
Yeah, actually, why don't you talk about the ABLE Act, then I'll talk about
just briefly about the ABLE Act. There's so many other things we could say. There's relatively new legislation available in California. It's a national law, but it's been implemented in California that lets anybody put up to $13,000 a year into basically a bank account for the benefit of an individual who is getting these government benefits and who is disabled. So there can be $30,000, $40,000, $80,000 over time in this account. The money can be used liberally, and none of it counts. None of it interferes with eligibility for government benefits. Sometimes it's a great idea, sometimes it's not. But again, it has to be on the list of planning opportunities and options that a family would think about when they have a child who faces some of these issues. Tremendous opportunity.
Yeah, and it's easy to set up an ABLE Act account. You don't need a lawyer for that. calable.ca.gov. It's easy to find. You can Google it and find information. And just as we talked about, this is an issue we think about a lot. We're passionate about it, and we actually wrote a book about this, the Special Needs Trust, very creatively named Special Needs Trust Creative and Management Guide. We finally made it available on Amazon. We were a little slow. We made it available to our clients for a couple of years, and we finally made it available. So you can order it on Amazon. And if you
the title's a little dull, but the cover's beautiful. Our designer just did a great job.
Right. Yeah. And it's a comprehensive book meant to be easy to read. It's not meant for professionals. We worked really hard on keeping it as clear as we could and just kind of a how-to guide for special needs planning, what you need to think about, because we think about this a lot. Well, let's transition. I think this is a good transition because we got to think about our homes. And if you have a child with special needs, or if you just want to protect your home for the next generation, there's a new issue we need to think about.
And, we always want to take a moment and just think about our homes. If we are fortunate enough to own a residence here in the Bay Area and Silicon Valley, it's ridiculous what's happened to our home values. They just keep going up. There's no end in sight. There's restricted inventory. More and more people are holding on to their homes, and there's still demand. A lot of folks are still striking it rich with the .coms. A lot of foreign money is coming in, and people want to live here. Notwithstanding all that we read about people leaving, people want to live here. So prices keep going up, which means a couple of things. One, it means that you may have estate tax exposure you didn't think about. But the other is Prop 19. The greater the value of your home at your passing, the more devastating the impact of Proposition 19. So let's take a moment and let's look at it and let you know what it means. Drink this in. This applies to everybody on the webinar who owns real property in the state of California. Probably 80–90% of us on the call right now. So what is it? What does it mean? And by the way, it is law. This isn't coming. It isn't something we're thinking is going to happen. It became law on February 16, 2021. Dramatic. Okay. To set the stage to understand it, you all know something about Prop 13, late 70s, law passed and voter initiative to basically take the level of property taxes way down. I mean, dramatically down, and restricted the increases ever since. More importantly, frankly, over time was Prop 58. And it said two things. First, it said you can pass along your residence to your child or children, and there's no property tax increase as long as it's your residence. Doesn't matter if the kids want to rent it out. Doesn't matter if they want to live in it. No property tax increase. The second thing it did, It said that in addition to passing along your residence of any value, could be a $10 million house, without a property tax increase, another $1 million in assessed value, not market value, but assessed value could also be passed along without a property tax increase. So we were all able to pass along our residence plus a second home or maybe a rental or two, no property tax. All of that is gone because of Prop 19. So what happens now? When you change title, if there's a sale, if you give your house directly to your kids upon your passing, there's a presumption that there will be a 100% reassessment. Property taxes could go from $4,000 or $5,000 or $6,000 a year to $30,000, $40,000, $60,000, $70,000 a year, obviously depending on the value of your home. The residence. If a child lives in the house and makes it his or her residence, then there is a small break that the first $1 million in assessed value is going to be protected from the property tax increase. Again, only if the child lives in it. The San Jose Mercury did us a tremendous disservice. It published not one, but two articles that I saw, and those articles both said that if your child lives in your residence, there will be no property tax increase. Absolutely wrong. I wrote letters to the editor. I called up a couple of reporters I know. I got nowhere. They just weren't that interested. But it does a disservice. So some folks are kind of lulled into complacency, thinking everything's going to be okay because my child is going to live in the house. Not so. There could be some protection, but not enough. Now, if you're passing along a vacation home or a rental property, there is no protection. There is no exception. There's a complete reassessment and no exception. So one of the most bothersome things about this, what if you're one of the many families who has a special needs child where housing, where that child is going to live is the most challenging, daunting, horrific problem families think about? Well, if you want your child to live there, but the property taxes are going to go from, again, let's say $4,000 to $30,000 or $40,000, is there going to be enough money to pay those taxes the many years your child is going to live? Probably not. So many of those families, they're going to be forced to sell the house to avoid these ongoing property taxes. The entire plan for that special needs kid right out the window. I mean, that's a just terrible outcome by any measure. So we're talking about saving tens of thousands a year if we can avoid this problem, millions of dollars over time, and our mystery illustrates this beautifully.
Let's talk about, let's revisit the mystery we talked about earlier with Tom, Jill, and Amos. Tom, Jill, and Amos, remember, they all start off in the same position. They all have houses worth $3 million. Again, not a huge house in the Bay Area, as crazy as that is. The assessed values are very low because Prop 13 kept them low. So during their lives, property taxes were only around $3,000 per year, even at the time that they all pass away, leave the house to their daughters in each case. When Tom passed away, remember, his daughter took the house and wanted to keep it as a rental property. So she doesn't live there. So no protections, full reassessment of property taxes to over $30,000 a year. Probably means the house is not a very good rental property anymore. Second, Jill, her daughter wants to live in the house. She moves into mom's house after she inherits it. And this is where the big misconception was. A lot of people thought, if my child lives in the house, no increase in property taxes. But as Mike said, only the first $1 million in fair market value is protected from a reassessment. So Jill faces a $20,000 a year property tax increase. Okay, not 30, only 20,000 per year forever. Amos, on the other hand, property taxes do not increase for his daughter. Why? Amos took steps ahead of time, and we've developed solutions for this. The steps he took was working with us to prevent this reassessment. And let's talk about.
So the main point here is that we have developed a presumptive primary solution that is going to work for most people. For some people, it's going to be a little bit different. We call it the Gilfix the Dynasty LLC. It involves creating one and probably two LLCs, coordinating a number of transfers of real property, multiple deeds. It takes months and months and months to implement, to be certain that everything flows as it should under the law with the recorder's offices. So it's not simple. There are definite complications. If it hasn't been solved before the law changed, again, the law is now in place. This is the solution. By the way, if your kids are going to sell the house, if they're not going to keep it, Prop 19 is irrelevant, right? Because there are no ongoing property tax reassessment issues to face. But the vast majority, they want their kids to keep the house. It's just been the cornerstone, a good investment, all good. So every situation is unique. But again, we have a presumptive approach that we believe is going to be successful in avoiding these massive property tax reassessments upon your passing for the benefit of your kids and grandkids going forward.
Yeah, and we need to talk to you about your situation, your goals to make sure it makes sense. But it's a strategy that it's a proven strategy we've developed. So something to talk about, something to be aware of. I think a lot of people don't even know that their kids are going to face this big increase. Let's transition to the death tax. We talked about it a little bit before. I always like this image for it because I think that's what people sort of picture, the Grim Reaper with a tax bill. Although if you take a step back, the Grim Reaper's paying the tax. He's got the bill, not your family. So if that was the case, that's great. But unfortunately, if there is a state tax exposure, and to be clear, it's not a death tax. It's not a tax on someone dying. It's a tax on their estate if it exceeds a certain limit. So I think it's a little bit of a misnomer, but it's something we need to be aware of and we need to plan for it. Again, 2022 estate tax updates, it is a 40% tax. So any dollar exposed to this tax, 40 cents of that dollar is going to go to the IRS if your estate exceeds the limit. Now, what is the limit that you can pass tax-free? It's a pretty high limit right now. It's $12.06 million, over $24 million a couple. So you might be thinking, well, that's a huge number unless I sold a company or, invest really, really, really well. I don't have to worry about this, although many in our community do have estates exceeding this issue. You definitely need to worry about it then. But you might be thinking, I'm way below this. Not a worry. Wrong. This is almost certain to change in the near future. We know for a fact the current law sunsets in 2026. That means that the exemption will be cut in half to about $6 million per person then. And keep in mind, the value of your estate is, if you own a house, if you have stock and other investments, it almost certainly is going to grow and grow and grow in the next few years. There might be a couple of bad years with the stock market. We don't know. But over time, the value of assets and investments tends to grow at between 5 and 8% per year. It doubles every 8 to 12 years. So your estate's growing right as the estate tax exemption is likely to go down, and it could change before then. We don't have a crystal ball. We don't know what Congress might do, but we know that the current law is set to end if Congress does nothing in 2026.
Did you say if Congress does nothing? Did you say that? Oh, there's a shocking insight.
Yes. And one misnomer too, the receipt of an inheritance is not taxable. So one really great thing is if you inherit assets, taxes are paid by the estate before it's distributed out. So if you inherit something, you don't have to pay tax on that. But again, the point I want to make here is you might think this doesn't apply. I don't need to be aware of this. Your estate is very likely to grow in coming years, right as the exemption is very likely, almost certain to shrink. And your estate is bigger than you think. Your estate is made up of life insurance. It's made up of retirement accounts. So if you have a life insurance death benefit, that's part of your taxable estate. Retirement accounts, 401ks, part of your taxable estate. If you inherit any assets from your parents, unless they create dynasty or family protection trust for you, that's part of your estate. By the way, if your parents are open, you should talk to them about them creating a family protection trust for you to avoid this issue. A lot of our clients do that. They'll actually pay for mom and dad to set up family protection trusts for them. So you need to be aware of this. Now, what are some strategies that are low risk and more sophisticated to avoid this tax?
First, let's look at let's call it the low-hanging fruit, the steps that are so accessible. You don't need a lawyer to give you any more sophisticated advice. These are the easy pickings. The first is this thing called the annual exclusion. This is the right that each of us has to give away up to 16. Originally, it was $10,000. A lot of folks think, oh, you can give away 10,000. That was the initial number. It's gone up, kind of been ratcheted up with cost of living. Okay, so each of us can give up to $16,000 to as many people as you like, related or not. Don't have to report it to the IRS. The receipt of a gift by a kid, by a grandkid, the receipt of a gift is also not a taxable event. So this is a freebie. You can also pay tuition, not all of the cost of education necessarily, but you can pay tuition for anybody. And that's another way of effectively making a gift, moving money out of your estate, win-win, not reported to the IRS, no problems at all. You can pay medical expenses for anybody. And by the way, you don't give your kid money to pay the medical expenses. You have to actually pay the medical care provider. And this can be, these days, as we know, an enormous amount of money if somebody encounters some sort of a of a medical crisis. Relatively easy to implement. If you're worried about estate tax, if you're blessed with that worry, certainly think about these. Now, beyond that, there are countless sophisticated strategies that are available and that we have used for many, many years. And the next slide will show that.
Yes.
Just makes this.
Look at some of the questions that we were getting. Sorry.
Mark is monitoring the questions and seeing.
We're going to answer a couple.
Yeah. So, we have so many things on this slide. So many acronyms. There's the SLAT, the Spousal Lifetime Access Trust. There's a GRIP. There's a GRAP. There's so many. I mean, in the book that I authored, I think I have a dozen different acronyms for some of the more sophisticated tools and techniques that we have used with success for decades. The idea being, how can you organize your estate to reduce or perhaps eliminate the estate tax? Many steps can be done. Again, the rich have been doing this forever. More and more of us are exposed to these issues and just have to take advantage of these opportunities. The first one that we listed, we always call that the grandparents' delight, because it's something that you can do, especially for the grandkids. So go back to that $16,000 annual exclusion. If you have a 2 or 3 or 4-year-old grandkid, you're not going to give them that money directly. If you do, it might go into one of these Uniform Transfer to Minors Act accounts, which means that when that kid is 18, it's his money. God knows what he's going to be like at 18, what's going to be going on. So that's often not a good idea. Okay. So the idea here is you create a trust. It's actually called a crummy trust. It's after an old tax court case. A couple can put up to $32,000 a year into that trust. The money can then be used for anything you identify in the trust: education, healthcare, housing, whatever the kid needs. Maybe that kid's parent, your child, would be the trustee of that trust. And you can have that trust last until your grandkid is 30 or 35, whatever age you pick. So again, it's a wonderful way of transferring money out of the estate for the benefit of a grandkid in a very wise, protective way. And over time, that's a whole lot of money that can be removed from the estate. I'm not going to go through the other techniques. Again, there are many. It's in my book. But I'll just tell you that the tools that we use are not crazily pushing the edge of the envelope. They work. The discounts that we capture by some of these approaches, they're remarkable in removing assets from your estate. So you've got to take advantage of them.
Yeah, sometimes in our field, we almost say that the estate tax is like a voluntary tax to some extent. You can volunteer to pay it if you want, but if you plan ahead as your estate grows and these exemptions shrink, there's so much we can do to protect against this. And they're well respected and great tools available. And this just goes to the point that you got to take advantage while you can. The current exemption is very high. There's a lot that we can do with that to protect assets, even if the law changes in the future. So take advantage of that. If you're not sure if you face these issues, we can help walk you through the issues you have and how you might solve it. There's no one size fits all approach, but definitely plan with certainty. And we got a good question from Amy that I do just want to address. This relates to taking advantage while you can. Prop 19, and she had a good question about when a parent dies and a home passes to a child, property taxes could spike, but can that child sell soon after in a tax advantage way? And yes, the current law allows for a stepped up cost basis. So a child can sell mom and dad's home after mom and dad pass away for little or no capital gains tax exposure. So that's one option. And as Mike said earlier, if you do just sell the house, well, the property tax increases are not so bad. Now you do have that increase from the time that a parent passes away until you sell. Even in 1 year, that could be an extra $20,000, $30,000, $40,000 in the time it takes to sell. But you do have that stepped up basis. So good question from Amy. Now let's circle back, by the way, to the tale of protecting assets, just to tie this estate planning section up. Wanda and Dave worked hard. They owned property. They ran a business. They ended up with a net worth of over $20 million, an estate of over $20 million. When they pass away in 2026, over $5 million lost in estate taxes. Susan and Jim, same situation. When they pass away in 2026, not a penny is lost in estate taxes. Why? Well, really simply, Wanda and Dave didn't want to work with lawyers. They thought that was silly to invest in advice. That's a waste of money to work with those lawyers. We don't want to deal with that. We're just going to earn and focus on our stuff. They didn't do any planning. And so their estate was exposed to millions in estate taxes. Susan and Jim worked with us. We worked with them over time to use crummy trusts and slats and maybe other tools and saved over $5 million. The return on investment for tax planning work is I don't think you can find another example of something with as high a return on investment, virtually guaranteed if you do the right type of tax planning. So again, knowledge is power. These tools are available. Even if you don't have a huge estate, you need to be aware of these issues and aware of the steps you can take starting right now. Now let's shift gears just a little bit, and we are getting close to the end. We don't have too much more to go through, but let's talk about long-term care.
We do worry that we cover too many topics in this webinar, but our goal is to do kind of a comprehensive overview, touch on the issues that affect virtually every family. And let's face it, long-term care and the cost of long-term care affects virtually every family. The data are that 75% of us over the age of 65 will need some form of long-term care. It may be home care, it may be assisted living, it may be, God forbid, skilled nursing care, being in a nursing home. All three of those are extremely expensive, and they're going to be more and more expensive as time moves along. You may have long-term care insurance or be interested in it. We can actually advise about that. We have the appropriate referral sources. But most importantly for the moment, there are a number of government programs that can help pay for the cost of care. Some pay for care at home. There's some that pay for the cost of long-term care. Now, Medi-Cal is often the most significant government program that we think about in this context. It can pay for all or most of the cost of nursing home care for qualifying individuals. It's a complicated topic. The law is relatively kind to us in California. You cannot give me a situation, a profile, an asset profile where, with good planning, we can't protect virtually all of the assets and achieve Medi-Cal eligibility within a few months. The law lets us do this. We're just a messenger here. The law lets us do these things. Importantly, as kind as the law is now in terms of planning options, there's new legislation in California that makes Medi-Cal even more accessible starting in July. The rules are changing to be liberalized and to allow individuals to retain even more assets while qualifying for these programs. So, the real point here is that, don't have your head in the sand about the cost of long-term care. It affects how we write the durable power of attorney. It does, because we have language specifically dealing with Medi-Cal planning, so to speak, in the context of your durable power of attorney. So you got to think about this and integrate it into your thinking. We raise this topic with everybody because it's there. You're not going to be, you can put your head in the sand, but in all likelihood, it's going to be an issue for you or certainly one of your dearest loved ones.
Yeah. And we wrote a book about this as well. We like to write articles and books and give talks. We like to communicate about these issues. Again, knowledge is power. We do have a book available to clients. And I think it's on our website, Facing the Reality of Long-Term Care. If you work with us and you're concerned about this issue, you can get a copy of this book as well. We think about these issues a lot, and they're meant for regular people, not just for lawyers. Not much legalese. In fact, no legalese in these books. Nobody likes that. So we threw a lot at you. I think the main point we want to make is that solutions exist. We've helped thousands of families in California. We've written books, articles, we give talks about this. We live and breathe this every day. And you need to work with a team that really thinks about this all the time. This is not something you dabble in as an attorney or as an advisor. You need to live and breathe this to really understand how these issues fit together. And that's what we do. And we have, in the work we've done in the last decades, we've saved clients conservatively hundreds of millions. And actually, we're pretty certain it's billions of dollars in taxes and long-term care costs by helping them to plan ahead and to coordinate across generations. And we just want you to imagine what can be achieved when you just take a few steps now. The impact it can have on your children, on your grandchildren, on making sure that you're covered if you get sick, on making sure your child with special needs or your loved one with special needs is protected for the rest of their life, and making sure that your kids are protected from divorce. It is incredible what we can achieve when we plan ahead and when we work together. Again, we write the books on this. Is another book we haven't talked about enough. Mike alluded to this before. Beat Estate Tax Forever. This was just Mike. I didn't co-author this one. And this goes into a lot of the other tools we talked about here today. Again, we live and breathe this. We think about it all the time. So you might feel overwhelmed right now. We threw so much at you, so much. This is like a masterclass in all the issues we have to think about. Perhaps too much, but our focus here is empowering you with knowledge so you're aware of the issues that you face. And it would be our privilege to get the chance to work with you and to bring this all together for you. It's our job to ask the questions, to figure out what issues apply, and to listen to your concerns and your goals and your dreams, And then we can work with you to take action and to protect your assets and make sure you're in a great place. What are some specific action items that we recommend? Okay, bear with us a lot. These might not all apply to you, but I bet at least a couple of them apply to everybody here watching this. One, you need a basic core estate plan. If you don't have a revocable trust and power of attorney that are developed the right way, you need to get that into place. We, of course, can help you with that. But even if you do, it's critical you take a fresh look. You need to make sure they're up to date for many, many different reasons. Laws have changed, your situation's changed. You need to address updates to that, or at least review it every couple of years. Protecting assets. If you don't have family protection trusts for the next generation, you should have those. Again, very powerful. If your parents might be leaving you assets, talk to your parents about setting these up. And of course, if you have a child or a loved one with special needs, you need to set up a special needs trust. Estate tax issues. If you're single and your estate is approaching $5 million today, a house and some investments, if you're a couple and it's approaching 10 million, you definitely need to be aware of these issues. They might not be pressing this moment, but they will be soon. Lots of tools available. Prop 19, if you have real property, a home and or rental properties or a place in Tahoe or whatever, massive tax increases when you pass away unless you take action. So you need to be aware of all these. It all relates to what your goals are. From what your goals are, your issues are, we can come up with really good solutions and let you know what's available. So we, of course, invite you to work with us. It'd be our privilege to get the chance to help you. You can join our client community. Very simple. You can call our office, or from this webinar, we recommend you reach out to Tim at Gilfix.com. He's coordinating follow-up appointments. You can also enter your name and contact information in the Q&A function if you're watching this live.
Which is the simplest way to do it.
The simplest way. Give us your information. You can also reach out to Tim at Gilfix.com. And if you are watching this as a recording, and reach out to our office, Tim, find us, Gilfix.com, not hard to find us. And in the way that we typically do things, we get this question all the time, a very fair one, is we want to be able to serve you from the moment we meet with you. So we typically do not offer free consultations. We bill hourly for our meetings, and we're there to plan for you. We can serve you as your attorney from the first minute we're working with you when we're doing a planning meeting. We bill at our hourly rates. They range from $495 to $695 an hour. In 1 to 2 hours, we can understand your whole situation and lay out a path forward with specific fees that would cost to build out the plan. So you would know exactly what the cost would be to build it out. Our focus is on return on investment and value. We want to make sure you have the right plan to serve you and future generations, no matter what your situation is. So contact us if you'd like to set a meeting. It would be our privilege to get the chance to work with you. If you're an existing client, of course, and these brought up issues, come back in and we can address your updated issues.